Aloha, WAIKAPU, and good morning. This is the October 5th, 2022 Land Use Commission meeting. This is an in-person meeting which is being held at the Maui Arts and Cultural Center, Haynes Meeting Room 1, Cameron Way, Kahului, Maui, Hawaii, 96732. Open, and it is open to the public. Court reporting transcriptions are being done via a Zoom platform, which is being recorded. For all meeting participants, I would like to stress the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. Even though this is an in-person meeting, please be aware that all the meeting participants are being recorded on a digital record of this Zoom meeting for the court reporting purposes. Your continued participation is your implied consent to be a part of the public record of this event. If you do not wish to be a part of the public record, you should exit the meeting at this time. I will also share with all participants that we will take breaks from time to time as needed. My name is Nancy Cabral, and I currently serve on the Land Use Commission as the vice chair. We currently have 9 seated commissioners. Commissioners are Lee Oigashi from Maui, Don Chang, Gary Okuda, and Kui Aki Kamakea Ohelo, Michael Yamani, Mel Kaheli, George Atta, and also is our chair, Dan Giovanni, who is excused from this meeting. In attendance is our land use chief planner, Scott Derrickson, land use planner, Riley Hokoda, our planner, Martina Sigura, okay, sorry, our chief clerk, Ariana Kwan, sorry, and our executive director, who will be joining us shortly, Daniel Orendecker. Also with us on Zoom is, from the Attorney General's office, is Julie Chena, who's with us via Zoom. The first order of business will be the adoption of the September 21, 2022 minutes. May I ask if we've had any written testimony submitted about the September 21st minutes?
No.
Okay. No, we have had no written testimony. Is anyone from the public here that would like to speak in regards to the minutes who may have signed up or otherwise sitting here at this time?
No, Madam Chair.
Thank you very much. Commissioners, would you like to make any corrections or comments on the minutes? If not, is there a motion to adopt the minutes from the September 21, 2022 meeting of the Land Use Commission?
Madam Chair.
Yes.
I move to adopt the minutes.
Okay. Commissioner Oigashi made a motion to adopt. Is there anyone that would like to second that?
I'll second that.
Okay, Commissioner Atta, thank you very much. It's been moved and seconded to adopt the minutes of the September 21st, 2022 minutes. Can I hear an A from all those in favor? Aye. Okay, anyone opposed? No one's opposed. Therefore, the minutes of the September 21st, 2022 meeting are adopted. Thank you for your support. At this point, we'd like to move ahead and get a tentative meeting schedule for the coming months. I'd like to ask if our Mr. Scott Derrickson could go ahead and provide us with a list of our upcoming meetings.
Aloha, Commissioners. I'm going to go over the tentative schedule coming up. Tomorrow, Thursday, October 6th, we're going to be doing a site visit to Waiahu 201H project. We're going to be meeting at the DOT airport offices first thing in the morning.
Directly into your microphone, young man.
Thank you, Chair. On Wednesday, October 19, we're going to be here for the adoption of order for the WAIKAPU motion to amend. On Thursday, October 20, there's no formal hearing. The LUC staff has ethics training back on Oahu. Wednesday, November 2nd, we'll be in Kona for a status report for A02737, University of the Nations, Bencor. On November 16, Wednesday, we're going to be on Maui again. We're going to be hearing the A19-809 Pulamalanai Miki Basin District Boundary Amendment. We're going to be beginning that petition process. In December, we have tentative meeting dates. This is not guaranteed yet, but we want you to try to save these dates. December 7 and 8, we are probably going to have a motion to amend for an Oahu project on the 7th, and then Kona project motion to amend on the 8th. On December 21st and 22nd, we are holding those dates. We have been informed that the Department of Education would like to come in with a motion to amend for Kihei High School. Are there any questions, commissioners?
Okay, no questions at this time. We appreciate you giving us our future. I take it we have Christmas off. Okay. Thank you very much. Okay. Okay, now for our order of business for today, A15-798 WAIKAPU properties on Maui. This agenda item is considered the petitioner's motion to amend conditions 1, 4, and 8B of the decision and order that was filed on February 26, 2018. I will begin with a brief explanation of the procedure. First, I will ask if there's any disclosures from our commissioners regarding this matter, and then I will update the records and ask the parties to identify themselves. Next, I will give an opportunity for the petitioners to comment on the commission's policy governing reimbursement of hearing expenses. I will then recognize the written public testimony that has been submitted in this matter, identifying the person or organizations who have submitted such testimony. Then I will call on those individuals in the audience desiring to provide public testimony for this matter. After completion of the public testimony, the commission will then consider the exhibits that the various parties wish to offer into evidence, starting with the petitioner, followed by the county planning department, and then the State Office of Planning and Sustainable Development. Then the petitioner will make their presentation and receive any comments or questions from the commissioners. Next, the county's planning department will make its presentation and receive questions and comments from the commissioners. That will be followed by the Office of Planning and Sustainable Development that will be making their presentation and receive questions and comments from the commissioners. Petitioner will then be given an opportunity to provide any rebuttal to that information. The public will then be granted another opportunity to provide public testimony in the same manner as set forth previously. Finally, after all the parties have presented their arguments, the commission will conduct a formal deliberations and issue a decision on the motion. I would also like to note that the parties and the public from time to time that we will be calling for short breaks, approximately 10 minutes every hour or so, and we will take a longer lunch break at lunchtime. If there's any questions about our procedures today, any questions from petitioner? Okay, County of Maui, State Office of Planning?
No questions.
Okay, thank you very much. Okay, disclosures. Do any of my fellow commissioners have any disclosures regarding this matter that is before us today? Okay, silence is golden. Okay, thank you. Make my job easier. I apologize already for I'm tone deaf my whole life and now with age deaf. So I will mutilate everyone's names and words as we go. Okay, let the record of this matter, let me update you. On July 19th, 2022, the petitioner filed a motion to amend conditions 1, 4, and 8B of the decision and order filed on February 26, 2018. On July 29th, 2022, the Office of Planning and Sustainable Development filed its request for a time extension. On August 1st, 2022, the State Land Use Commission responded to the Office of Planning and Sustainable Development's request for time extension. On August 12th, 2022, the Land Use Commission received and posted the county's memorandum, position statement, and certificate of service. On August 17th, 2022, the Land Use Commission received the hard copies of the county's memorandums, position statements, and certificates of service. On September 20th, 2022, the Land Use Commission received the Office of Planning and Sustainable Development's response to the 2022 motion to amend conditions, Exhibit 1, and the certificate of service. On September 26, 2022, the Land Use Commission mailed the October 5 and 6, 2022 meeting agenda notice to all parties and to the statewide email and MAUI mailing and email list. Party identifications. Will the parties now identify themselves for the record? Petitioner. Is your light on red?
Yeah.
Okay, go ahead.
Oh, okay. Good morning. Jeff Uyoka. I'm representing WAIKAPU Properties.
Okay, thank you, Mr. Uyoka. Okay, have you reviewed HAR 15-15-45 regarding the reimbursement of hearing expenses?
I'm familiar with it. Thank you, Chair.
Okay, thank you. And would you like to state your client's position with respect to this policy?
We're accepting of it.
You're accepting. Thank you very much. Okay, now at this point, I'd like to go ahead and do we have any public testimony? We recognize any written public testimony submitted in this manner, identifying the person or organization submitting the testimony. Okay, thank you. Oops.
Give their appearances.
Oh, okay. Okay, well, it didn't say that, so I just went on with it. Okay, thank you. Thank you for the correction. I'd like to go back to identification. All right, good. Petitioner, Mr. Uyoka, you have other people present now with you?
Thank you, Chair. We have Mike Atherton, one of the partners in the project, and Dwayne Ting, he's a project manager assistant. Thank you.
Okay, I'm sorry. I heard Mike Atherton, and what was your other person?
Dwayne Ting.
Dwayne. Okay. Okay, thank you very much. And then can Maui County Department of Planning identify those people present with you today?
Certainly. Good morning, Chair and members of the Commission. It's good to see you in person. Michael Hopper, Deputy Corporation Counsel, representing the Maui County Department of Planning. With me are Planning Director Michelle McLean and Planner Denny Diaz.
Okay. Okay, thank you very much. And with our State Office of Planning and Sustainable Development.
Good morning, Deputy Attorney General Brian Yee on behalf of the Office of Planning and Sustainable Development. With me is Lorene Maki from OPSD.
All right, thank you very much. Moving on. We have no public testimony still. Oh, we have written. I'm sorry. Thank you very much. No written. Okay. Okay, so no one, and we have oral testimony, folks that have appeared and have signed up now to present. Okay. They're signing up now. Okay, well, let me give you a minute to get that signed up, and then we will ask those present that want to testify. We're going to ask them to come up here to the seat on my far right near the door with the bright light coming in. And I'll swear them in, and then they can provide their testimony.
have one oral testimony today for Johanna sorry. And so I'll have her,
Yes, please. If you can you come up forward here? And we don't have a microphone for that, though. Steal a mic.
I will do this mic. So we'll try. It's gonna give a little bit of effort. Loudly and clearly.
Okay, thank you for coming today. Can you please state your name and your address for the record?
My name is Johanna Kamala. I live at 222 Waikappu Avenue.
Okay, thank you. And may I swear you in?
So,
May I swear you in? Okay. Do you swear and affirm that the testimony that you are about to give is the truth? Okay, thank you very much. Go ahead and proceed to make your statement.
as to the 4 items that are being requested for your attention, there's a couple of things that's going on in our community that I'm surprised these projects are getting funds for. And one is that we still don't have a water plan in place. Secondly, I understand the dilemma the developer is in to have to provide a school. But to put that onto the community by adding more properties, more units to the project is really asking us to pay for it. That's how I look at it. To me, it just kind of comes down to not enough foresight in this type of plan, and that's what people are all about, planning. And why wasn't it brought to his attention early to put the school into the program? And the costs were much less. And then on top of that, the traffic problem. We already have traffic issues in Waikappu town when school gets out and gets in the morning. And you're going to add more to the project. Hopefully the school there will take the brunt of it, but we still have a narrow passage, just one road in and out past that area. And that's pretty much what I wanted to say.
Okay, thank you very much. Can you just wait 1 minute? And I'd like to ask, does the petitioner have any questions of the witness?
Thank you, Chair. Ms. Kamala, I don't know if this is more of a question or a statement, but were you aware that we're expanding the present school site? We're not increasing the density of the project anymore. There's an increase in the amount of affordable housing that will be in the project, but there will only be 1,433 single-family units or a mix of single-family, multifamily units in the project.
And the size is not increasing, just
No.
the number of units.
No, the number of units is staying the same. We're just going to get a little denser in other areas because we're expanding the school site. We already had a school site. It was 12 acres. Now we're proposing to go to about 24 or 25 acres for school because there was supposed to be the intermediate school down at the A&D Waiale project, but the county, recognizing the cultural significance of it, purchased that property. So there was supposed to be a school in there. So the state legislators asked us for additional land in Waikappu Country Town to make a bigger school site so they could have an intermediate and an elementary school in Waikappu Country Town.
They will all feed into Baldwin.
I'd assume so, yeah.
And what's the capacity for that school?
I don't know. We just were asked for land. We're not, the DOE going to figure all that out. We just were asked to give land, so we were trying to accommodate.
The land size is sufficient for intermediate and elementary.
I'm not an expert on school sizes, but I was told it should be good enough. I don't know.
I worked at the school for almost 20 years, and we went from a very comfortable setting to a very tight setting. Where we had teachers and we had counselors in the process. That was it. So yeah, I really can sensitive to schools and what you can compare for student learning and for the staff. That would be my concern. And the traffic.
Hey, thank you. I ask that you direct your questions or information so that we're to us. It's a delicate situation. Okay, thank you very much. Petitioner, any other questions of this witness?
No, thank you, Chair. We will work with traffic engineers and the DOE and hopefully a good solution can come out. Thank
Okay.
you.
All right. Thank you very much. Now, I might ask the Maui Department of Planning if they have any questions of the witness.
Oh, no questions, Chair. Thank you.
Okay, thank you. And State Office of Planning and Sustainable Development, do you have any questions of the witness?
No questions. Thank you.
Okay, thank you, Mr. Yee. Okay, thank you for coming forward and expressing your concerns. We absolutely do appreciate that. Thank you. Oh, I'm sorry, commissioners have questions. I'm sorry. I have a script. I'm a substitute teacher today. Yeah.
I'm sorry.
Commissioner Chang, please, with your questions.
Good morning, Ms. Kamanu.
Yes.
Good morning, Ms. Kamanu. Thank you so much for being here today. I was wondering,
I'm sorry.
no, okay. Oh, sure. No, that, hey, sister, we're all part of it.
Yeah.
Me too. I'm sorry. My apologies. Let me ask you, I think my recollection is when we approved this project, there was a lot of community engagement. There was a commitment to engaging the community, which I think for me made a big difference. I'd like to ask you, since that approval, which is I think about in 2017, has the developer come to the community to tell you about these changes?
Has he come to the community?
Yes.
If he has, I wasn't aware of it.
Are you aware of any public meetings? Since,
As far as, I'm sorry.
Wait.
no, I was wondering, has there been any public or community meetings since the approval of the project?
I don't know whether to go personal or community, but there are concerns about the project. The fact that it's in the Wai'eha and the use of that land is something contrary to its.
Okay. Did you, in 2017, when we had this, in 2017, when we had the original petition, were you contacted and participated in the proceedings before Land Use Commission?
2017.
Yeah.
I don't think so.
Okay. Have you've expressed that you've had some concerns? Have you had the opportunity to raise those concerns with the development team? Okay.
I don't think we're in a situation.
And how did you become aware of this meeting today?
I'm here for the-
Oh, all right. Okay. No, thank you so much for being here. I have no further questions.
Other commissioners have any questions of our witness today? Oops. Any other questions from our commissioners today? Okay, thank you very much. Okay. Yeah, anyone else from the public who would like to make a statement or have a presentation at this time? Okay. Okay. Ariana, Kwan, we have another party in the back that would like to make a statement. Okay. We do try and recognize and give everybody their time to give us information. Thank you.
With one more testifier, Carol Lee Kamikona.
I want to appreciate our staff trying to be both here in person and on Zoom, and technology combining doubles their workload and the challenges we all face these days. But I think it's a better product in the end. So appreciate the efforts. Hey, thank you. Can you go ahead and provide us with your name and your address at this time?
Aloha kakiakia koka koko uno o Carolee Kamikona ma Kahalui, 862 Makaliki Street, 96732.
All right, thank you very much. May I swear you in at this time? Okay. Where did that go to? Get the right words here. Okay, do you swear or affirm that the testimony that you are about to give is the truth?
Affirm.
Okay, thank you. Go ahead and proceed.
I would just like to say that I know Coach Mike's, hello Mike, Coach Mike's project has gone through a lot of rigorous dissection from a lot of different entities. I am in support of the project. My biggest concern, however, is traffic mitigation. My understanding is this project is MAUI of Honoapi'ilani Highway, and Honoapi'ilani Highway is the only road that traverses the area. So I'm seriously concerned about how 1,400 units times 2, I'm going to estimate at least 2 cars per unit, are going to be able to go in and out of that project area without adding more impact to the already congested traffic in and out of Wailuku to Lahaina and Ma'alaya.
Okay, thank you for your statement or question. At this point, I'll go ahead and ask, does the petitioner want to have any questions of the witness that's here with us at this time?
We're fine. Thank you, Chair.
Maui County, planning, any questions of the witness?
No questions, Chair.
Okay, thank you. State Office of Planning and Sustainable Development, any questions of the witness?
No questions. Thank you.
Okay, commissioners, any questions of the witness? Okay, well, thank you very much for coming and making your statement.
Did? Okay.
Oops. Moving right along. I'd like at this time to proceed with the admission of our exhibits. Petitioner, Mr. Uioka, do you have any exhibits that you would like to have admitted into the record?
No, thank you, Chair.
Okay. Maui County Planning Department, any exhibits to admit into the record?
No, Chair.
No? Okay. State Office of Planning and Sustainable Development, any exhibits for the record?
The only exhibit we submitted was submitted with our statement in support of the motion. Were you looking to introduce those, or are those already considered to be part of the record?
Those are already considered part of the record.
We have
Those are already considered part of the record.
We have no additional exhibits.
Okay,
Thank you.
Thank you very much. We should add additional to this script. Thank you. Okay, hearing none, petitioner, that we will clarify that the exhibits already presented are already officially part of the record and are available upon request. Okay. Okay, so we have, and I'll ask now from the exhibits that have already been submitted, are there any questions or objections from any of the other parties regarding those exhibits that have been already shared among the various parties? Okay, petitioner, no?
No question. or
Okay, Maui County,
No
no?
objections, Chair.
Okay, state?
No objections.
Okay, thank you very much. Okay, gotten with taking care of that business. Presentation now, petitioner, Mr. Uioka, would you like to go ahead and provide us with your presentation at this time?
Thank you, Chair. I'll try to be brief. So what we're requesting is recently we worked with the County of Maui on a public-private partnership agreement where in lieu of providing direct funding or construction of certain infrastructure improvements, and we'd be providing additional residential workforce housing units in WAIKAPU Country Town. So in addition to that, we were also asked to expand the school site in WAIKAPU Country Town. So we looked at our conditions from the district boundary amendment, and the first one was the education contribution agreement. Want to make clear that we will probably be amending that and we'll be complying with it as amended, and we'll need to work with the DOE on the amendment naturally. The next one was for wastewater. The requirement is to participate in the funding and or construction of adequate private or public wastewater facilities, essentially. And we wanted to make sure that the condition was clear that alternatively, pursuant to separate agreement with the county, which would likely be our PPP agreement, would be able to provide additional residential workforce housing units in the project in lieu of participating in the funding and or construction of adequate private or public wastewater facilities to accommodate the proposed uses of each portion of the petition area. The next one was in regards to traffic impacts. So one of the requirements of our conditions of zoning was to participate our pro rata share in the funding of the Waiale Road extension. The county was supposed to be, or not supposed to be, the county is going to be building that. I believe they recently got a federal raise grant to also help fund it. And again, the language amendment would be to allow the petitioner, subject to the agreement with the State Department of Transportation and the County of Maui, provide additional residential workforce housing units in the project in lieu of providing funding or constructing traffic improvements to mitigate the traffic related to the impacts of the project. So in discussions with state DOT and the County of Maui, their understanding of the concept, we'll still need to go back with them and have memorandum of agreements produced and signed by each of them in regards to the conditions of the DBA and zoning regarding traffic impact mitigation. I saw in the staff recommendation, there was a question regarding the Waiale project we were referencing in our moving papers. And that was essentially to A and B had a Waiale North and South project more towards Kuihilani Highway. However, that property was purchased by the county, and my understanding it is not going to be moving forward. So there was a loss of a lot of housing. And part of the impetus of the PPP agreement was we could pick up some of the affordable housing that was supposed to be in there in WAIKAPU Country Town. Not all of it, but some of it we could help. And then also the intermediate school site, we were requested to help to address that in WAIKAPU Country Town. And we feel that regarding compliance, verifying compliance, we'll still be working with the Department of Planning and the various entities that still need to execute other agreements with us to effectuate the terms of the PPP and the actual agreements regarding traffic and I guess wastewater's taken care of for the most part, but primarily traffic and education requirements. I am looking at some of the other questions they had, and regarding the opportunity cost figures that were in the PPP, those were just calculated by, there's a lot of ways you can calculate the cost of housing. Why we chose, well, opportunity cost was more subjective in my opinion. We took a valuation of 180% AMI, the cost of a 3-bedroom unit at that price, and compared it with the cost of the various units at different AMIs required by Chapter 2.96 Maui County Code, the county's residential workforce housing policy, and took those differences for the 213 additional units. And that was a calculation for the opportunity cost value. At this point, I'll stop. And if you guys have any questions, please let me know. Thank you.
Thank you, petitioner. I'll see if there's any questions. Commissioners, do you have any questions at this time of the petitioner? Okay, Commissioner Chang.
Good morning, Mr. Ueoka and Commissioner Chang. Thank you so much for your clarification. Your earlier clarification for Ms. Kamanu helped me understand you're not increasing the total number of units, just the density of the affordable housing units, or the workforce housing units. That's correct. Okay. The question that I have, I'm not as, I like to compare apples and apples, and I was having a difficult time with all the different numbers. So I'm trying to determine whether what you're giving up, in other words, the costs for wastewater, the cost for traffic. What have you quantified? What are those costs that you would have otherwise been required to contribute towards? What was the total cost?
I can't give you precise figures, of course, because, we don't know when we'd be building or doing them, but our understanding is based on our traffic analysis, we would have been responsible for, I believe, 41% or so of the total cost of the Waiale Road extension. We don't have a solid figure from the county on what the Waiale Road extension will cost, but we were estimating, I want to say, don't quote me on it. Actually, I know that's horrible in this kind of hearing, so don't quote me on it, but I want to say it was in the portion of Waiale Road extension that our pro rata share would have been required to contribute was, I want to say 20 to 25 million, but
Okay.
that's a moving number. I think the total cost will be more, but my understanding was they wouldn't assess us for the entire cost. And recently they got a $25 million federal raise grant to pay for the Waiale Road extension. In regards to sewer treatment, we estimated the cost of us building a private facility would have been around 20 million. Who knows what it, costs escalate and move, but that was our estimate at the time of the PPP agreement.
Okay. And can you quantify for me the difference between, and bear with my math, you're adding 63 workforce housing units. Is that correct?
So, thank you. So it should be, if everything goes according to the PPP, a total of 213 additional residential workforce housing units. Our requirement per chapter 2.96 was 287.
Yes.
And if everything goes accordingly to the PPP, there'll be a total of 500 in Waikapu Country Town. Okay. They were still maxed out at 1,433 though.
Can you quantify what is the difference between, because you're still able to build you're still able to build residential housing, but it's not market. So how much less market housing are you building? Are you not building?
213
Okay.
is being converted from market to residential workforce housing.
Okay. And again, I'm trying to do apples and apples. Are you able to quantify the difference between what the developer is going to make or less in the number, given that it's workforce housing versus he's giving up market? Are you able to quantify that?
I guess you use the word make, and I'm assuming that means profit.
Yes.
I can't tell you what the profit margins will be in the future, of course. The only thing I could quantify in my attempt, and you can say, everyone has their opinion on my attempt, of course, but it was to compare the prices in the Maui County's affordable housing guidelines at the area median income groups required. And it's a 30, 50, 20 split. 30% are required in below moderate, 50% in moderate, and 20% of the affordable housing units are above moderate. So I took the average value of that and I got a residential workforce housing unit sales price. And those were at 80 to 100, 101 to 120, and 121 to 140. So for this calculation, for the exercise of the PPP, we kicked out the table for the affordable housing sales price guidelines because it's linear. We kicked it out to 180%, and we treated that as the quote unquote market value. And that was a price of $951,500 per unit. And I thought that was a fair number, being that the median income sales price median sales price on Maui was well over $1 million at the time. But If you subtract that 951,500 from that, you subtract out the average sales price in those income groups and multiply it by the number of units in each income group, you come up with that number of 22,368,100 as shown on Exhibit A of the PPP.
Okay.
So I think that's apples to apples, but I don't know.
Okay, well, that's helpful. So about 22, because it appears as if your share of the infrastructure cost would have been around 45 million.
Oh, sorry, my apologies. We're talking about the 63. The balance of 150 would have been another 53 million.
Okay,
So we're estimating at about 75 million.
okay.
Yeah.
All right. And the reason I'm asking this is because my recollection, and I went back and looked at the original docket, there were testimony, in particular by Maui Tomorrow, raising concerns about the wastewater treatment, the traffic, the things that are being requested to be modified. And so, you know, I'm wanting to make sure that there's still some larger community benefit, that those issues that were raised in the original docket, which set forth the conditions, are being satisfied. So, and it's just not clear to me. So your representation is that these modifications, one, they're at the request of the government to assist them, but how do we assure that the public is going to get in a timely fashion the benefits of that, with the problems with the wastewater and the traffic?
Thank you. I completely understand them. So I guess there's all kinds of problems on Maui and everywhere, of course. And one of them was affordable housing. So the county really viewed the trade-off to get additional affordable housing. And the trade-off was, of course, that, you know, they'd take care of some of our traffic requirements. So the requirement was always for them to build the Waiale Road extension. And that is supposed to, according to the state and the county, it's supposed to truly address a lot of the traffic issues. Won't fix everything, of course, but it'll address some of them. In regards to the wastewater treatment facility, the county needs to build one in the central Maui area. They're trying their best to get out of Kahului. We want to work with them. In discussions with the Department of Environmental Management and the mayor, I think everyone felt it'd be a little strange if Waikapu Country Town had their private wastewater facility for around 750,000 gallons, maybe 1 million gallons. And then there's a big county one down the street for 2 million gallons. So the idea was to combine them. As far as to making sure that it happens all in a timely manner, that I will not make any promises on, just because we don't control the road building. We don't control the wastewater treatment facility. We can control to a certain extent, we control the building of the homes in Waikapu Country Town. So in the first 300 units, which is the subject or, you know, part of this PPP agreement, 150 of them will be market and 150 will be residential workforce housing units. So in the first, we're going a 1-to-1 ratio, which is above and beyond in the idea of trying to get that affordable residential workforce housing out there sooner.
And Mr. Uoilka, I greatly appreciate your candor. I understand, you know, you are constrained just within, you know, what you as a developer can do. But I mean, I know I was personally very impressed with Mr. Atherton and his commitment to this community and the outreach that was done for this project. So let me ask you, what's been the follow-up with the community since the Land Use Commission approved in 2018 the DBA And again, I think for me in particular, these modifications that you're proposing to make, given that these were concerns that the community raised at that time.
2018 it got approved, and I will admit, internally just getting stuff moving around. Then in early 2020, there was a little bit of a worldwide thing going on. So the pandemic, we didn't do much community outreach at that period. And then during the pandemic, then this all really came about with the county purchasing A&B's Waiale project. So Coach, I believe he did meet with the WAIKAPU Community Association once. He went to their meeting. But generally speaking, we went to the county council hearing for the PPP where the council supported it. That was another public hearing. And I guess this isn't a good excuse, but it's a reason. These opportunities were brought to us by government. So we weren't sure if we should go out there and talk about it too much, being that it wasn't necessarily our proposal. We are supportive and we want to do it. And the other thing too is, and maybe this is my fault a little bit, but didn't want to talk about all of this too much until we had approvals in place, more or less. And the county made it clear to us that the PPP, nothing's in place until we get the LUC's blessing and we get the county council's change in zone blessing for the change in zoning. So those are the reasons, more or less. Thank you.
Mr. Uyoka, I appreciate the candor. I mean, I think you are, you can only do so much. So thank you so much. I would urge that there, especially Maui Tomorrow, since they were the ones who raised it, that was a major issue, that there be outreach to the community, because I understand workforce housing is a critical need. But at the same time, the people that live in that community, their concerns were traffic, wastewater, and now they're getting, who knows when they're going to get those things resolved, but they're going to get perhaps, a denser, it may not be increase in the number of units, but there will be a large project and then the increased school. So I would urge you to continue to engage this community, because that was, again, for me as a commissioner, an important consideration in this approval. Thank you very much.
Okay. Okay, thank you very much, Commissioner Chang. Any other commissioners' questions? Okay, Commissioner Ohigashi, please.
Thank you. These are new workforce housing requirements that the developer is willing to undertake, assuming that it gets its offset, right?
Yes, Commissioner Ohigashi.
There was a recent ordinance passed regarding the income levels of modifying the income levels of different potential buyers of this, and limiting it to a certain amount of, well, I'm not totally familiar with the ordinance, but limiting. Is this additional workforce housing development part required to follow that ordinance, assuming that it doesn't get vetoed and it passes?
Thank you, Commissioner Ohigashi. So Bill 107 recently passed the county council, and amongst other things, it changed. Traditionally, the county had calculated the affordable housing sales price guidelines using 30% of annual or gross annual income or whatever going towards principal and interest of a mortgage, assuming 5% down and whatever the prevailing interest rate. The county council bill changed that from 30% to 28%, which in essence lowers the prices that affordable housing can be sold at. So this project would be subject to those changes.
Assuming that it's.
Yeah, assuming, yes.
Okay, now,
Thank you.
I'm going to ask you this. Public-private partnership agreement attached as Exhibit 1. Has it been recorded?
It is not a recorded document.
Is it going to be recorded?
I don't think so.
Now, I noticed that this is an administrative agreement signed here by the mayor and various staff. What happens if the administration changes? Does this agreement still remain in effect, given the fact that it's not recorded?
We believe so. It's a signed document. It's a agreement between the county and Waikapu Country Town. That's our hope.
Is your answer, maybe I should ask Mr. Hopper?
Probably he could tell me better.
Okay, I'll ask him when his time comes up. Okay. And getting back to my first question, does that change any of the calculations that you made in this, in your exhibit? I forget what is it, Exhibit A, I guess, opportunity of cost of additional.
Thank you, Commissioner. Yeah, and in theory, it makes the opportunity cost greater for the Waikapu properties.
And would that mean an additional amounts of funding that the county and the state and the DOE would have to take into account in order for your numbers to work out?
We'd love that, but as the way it is right now, we're okay moving forward. With the deal is the deal we had at the time, and we're willing to move forward even with the change. But we'd like to try and work with the county for some type of accommodation on that.
Would that decrease the total amount of units that would be in modified, your estimate of the total amount of units that would be modified for workforce housing development?
Thank you, Chair. I haven't discussed it completely with the partners, but the latest discussion we had is they're going to stand firm at 200, giving the 213.
Okay, and the problem is that if you make that commitment, the DNO usually indicates that you will live up to all commitments that you make in front of the Land Use Commission. And I'm giving you the opportunity to say that we're not sure whether or not we can reach that commitment, given the new law that was passed, and given the change of administration that may occur or may not occur. So I'm giving you the opportunity because if we do adopt this, there's a lot of language in the DNO saying that, hey, you got to live up to every single representation that you make in front of us.
No, thank you, Commissioner. I think we're okay with living up to the terms of the PPP. If the world goes sideways, we'll come back in front of you and the county council again.
Okay.
Thank you.
Madam Chair, can I go? Are you going to take a break or should I go on?
No, let's go ahead and finish.
Okay,
this part.
I have a question about the DOE. The land that you propose to give them is part of the DNO. In other words, it's urban land. Is that right? The additional land.
That is correct, Commissioner.
Okay. So you're not going to require any, they're not going to be required to come back to this commission for any kind of things other than modifying any kind of conditions that is not to their liking in the original DNO.
That is my understanding, but I won't make any commitments as to what happens in the future on that aspect. With
I'm not sure, but I was trying to look for a letter from the Department of Education or a comment or statement from them indicating that they are amenable to this agreement. Have you obtained any type of commitment from them?
I've not received a commitment from the DOE. I did speak with, I'm not sure if he was a deputy super, someone in that, the DOE regarding planning, and they were aware of it and they are willing to work with us moving forward. But this was we were asked to give and we're giving the DOE. We, sorry,
Did that come from the DOE itself or from the legislature?
a couple of state legislators asked us to help.
Okay.
Yeah.
And so internally, the DOE would not know what to do with additional land. Is that right?
Well, I don't want to say what the
Okay.
DOE is internally.
I just advise you that our dealings with the DOE has indicated that they are not necessarily people that you can rely upon for what they represent to you. So I'm just suggesting to you that it may behoove you to get some kind of letter of support from them and some kind of understanding that they will they may be subject to the terms and conditions of the entire DNO.
Thank you, Commissioner. And again, our amendment today is just to allow for an amended education contribution agreement. So we still need to work that out with the DOE and that type of thing. So thank you.
I forget, the 12 acres were recommended by the DOE, right?
I believe the initial 12 acres, that's what they asked for an elementary school. Thank you.
And how does this all work? Because I'm just curious. I don't know. You have the county and the state going to make decisions on when they're going to put in their improvements, right? So if they put in if they don't put in the improvements, does that mean you still will have to build your own transmission line and still participate in the development of the traffic improvements in that area? In other words, if they don't get the complete funding for it, do we go back and say, hey, we're back to square one on this matter?
Thank you, Commissioner. So the way the PPP structured is, we'll do the additional 63 as soon as we can. And with that, we can use the Kahului wastewater treatment facility for the first 300 units in the project. We can go there. So that's, our understanding is there's capacity. It's looking great right now. As far as the Waialae Road extension, the idea was we're gonna still have to work with state DOT and county regarding our traffic mitigation. We're supposed to do separate MOAs per the conditions of the DBA. Hopefully that all goes through. The Waialae Road extension goes smoothly. I believe now that they have the RAISE grant, it's a lot better than it ever looked before that it's going to happen. Regarding timing of all of it, I wish I had more control and things would happen faster, but I don't control that. So that's one of the biggest issues of the
I'm
partner.
trying to get an idea of when we start breaking ground and
well,
and actually people living in the houses. So I'm just curious.
Well, those are two different things, right? Breaking ground and living in houses, of course. But our hope is that we just recently turned in a large lot subdivision application. So with that, we probably can get some comments and start working on the backbone infrastructure. We're hoping early next year sometime. And depending on how long the backbone infrastructure takes, soon thereafter, there should be homes and soon thereafter people moving in, but those I'm not as, it's the timings, everything, right? It's difficult to predict.
You know, when I first was placed on the commission, this was one of the first projects that I had. And I sat here and I listened to everything and I didn't know what I was doing half the time, but I listened and it sounded like a good project. My only comment is that I was looking under your wastewater proposed language and the previous language. And it talks about if private wastewater source storage and transmission facilities are located outside the petition area, and when the state and county agricultural edition, petitioner shall apply for the state special permit in accordance with the provisions of HRS 205. I'm gonna say this is that I'm not sure if even, I'm not sure at this point in time if a special use permit is the applicable standard to be used if we're going to build a large sewage treatment plant on an agricultural property. And I think that your change of language would include that it would be the county who would have to seek that. And I'm concerned that a permanent facility such as large as a sewage treatment plant in the agricultural area would not necessarily get a special use permit.
If I may.
Yeah.
Oh, thank you, Commissioner. I believe that condition was the idea when we were building our little small one.
Yes.
Yeah, but now we're
but
going
it-
public, yeah. Now it's gonna be a public facility.
Yeah, but it says right here. But it doesn't get rid of that, does it?
Oh, I think God, I hope it doesn't happen, but in the event that the county does not move forward with its large treatment plant, we still need the ability to move forward with our small one, so the project still could.
So in other words,
If the county doesn't build, we still need to be able to build our small one, which I think is an appropriate use for a special use permit, because it's much
a
smaller.
special use permit may not be a good idea for a county large wastewater treatment facility.
I'll leave that to the county guys to figure out their land use entitlements.
Okay. I don't have any other questions.
Thank you, Commissioner Ohigashi. At this point in time, before we move forward, I'd like to recognize that when Commissioner Chang was speaking and having her questions, are from the State Attorney General's office. Daniel Morris entered our Zoom meeting, and I think somewhere in that time frame, Attorney General for the Attorney General's office, Julie Chena left the meeting, and then also just a few minutes ago, our Executive Director Daniel Orendecker has joined us here in person at the meeting. So just to keep the record clear. Now I'd like to go ahead and proceed with more questions from the Commissioner of Petitioner at this time, and then we will take a break if we can finish those up in a fairly rapid manner. Thank you. Okay, yes. Commissioner Yamani. Oh, there.
Okay, good morning, Mr. Wilco. Thank you. Just had a question and maybe help me understand. I'm a new commissioner here, so obviously I wasn't here when these conditions were imposed. Maybe you're new here, but on condition 8B, looking for your understanding on how it changes the condition with the proposed insertion of the language alternatively. So the way I read this, the intention of condition 8B back then was petitioner shall mitigate all project generated traffic impacts as recommended and or required by the state DOT and the county of Maui. So that was to me the general whole idea of that condition. Now the language alternatively petitioner, I won't read everything, but when I read that, and you can correct me if I'm wrong, does that mean if you provide additional workforce housing that you don't need to mitigate traffic generated by the project? Do you read it that way too?
Thank you. Yeah, Commissioner Yamane. Can I expand? I want to say yes, but may I expand?
Sure.
Okay, thank you. Typically in discussions, and I still need to, I shouldn't say we still need to enter into separate agreements with the state and the county. But generally speaking, my understanding is a lot of times for these smaller type of requirements, they don't actually have you build it. They have you either contribute money or do something else. So in discussions with state and county, they were saying, instead of contributing like a little bit here, a little bit there, you're just putting a bigger chunk into the Waiale Road extension, which they feel is one of the biggest traffic needs in this area right now. So that's the idea. That would be our mitigation, would be our larger contribution towards the Waiale Road extension.
Okay, yeah, and I kind of see that because when I look at the other condition regarding wastewater, the condition was that you will participate in funding and construction. So in lieu of that, But on this condition 8, and I'm not going to speak on behalf of commissioners that were here imposing this condition 8, where it specifically says that the petitioner shall mitigate. Doesn't say fund or participate on the traffic imposed by this project. It specifically says shall mitigate projects generated traffic impacts as recommended. But the in lieu is kind of referring to what you're saying, funding of and participation of traffic. So I'm kind of, wanting to make sure that the conditions imposed by the Form LEC is what is the intention, and if it's kind of being circumvented, because now it seems like the agreement, it will be specifically with the petitioner and the DOT and the county instead of what the LUC imposed conditions was prior to that. So
I'm sorry, and I understand where you're coming from. I just the idea also was that we're gonna initiate, coordinate, and meet with state DOT highways and the county to agree upon the regional pro rata share and to develop. So I believe there was at least the idea in there of cost sharing. I too wasn't here in 2018, but that's my understanding, is that second portion about pro rata share made this more understandable or relatable. Thank you.
thank you for. No more questions, Madam Chair.
Okay, thank you, Commissioner Imaki. Anyone else of our commissioners would like to make a comment at this time? Okay, sure. Okay, Commissioner Okuda.
Thank you, Ms. Chair. Can I ask a question? It's more a law question, since we are quasi judicial, and it deals with how much deference we have to give to an agreement that has the signature of the county, of you or your client, and countersigned by the various departments of the county. Is there anything in the law that addresses what deference, if any, we have to give to this PPP or public-private partnership agreement?
I'd actually prefer not to answer that question and provide legal advice to the board itself.
Well, let me rephrase the question. What is your position or your client's position as far as what amount of deference, if any, we have to give to the fact that this was a locally agreed to agreement? And by the way, I'm not asking a question because I once said we got to remember we're not the state of Oahu. I'm asking a question because since we have to be, a quasi judicial body applying the law, I just want to know if you can tell us what your position or your client's position is as far as what deference, if any, we have to give to the county with respect to this agreement. And I'll ask the same question of the county and the Office of Planning.
Thank you for the clarification, Commissioner Okuda. I'd love to say you have to give it full deference, but in reality, I believe in the PPP, it says it doesn't come into effect until the amendments are reflected in this, the conditions of the district boundary amendment. So it's still a discretionary determination on the part of this board.
So in other words, we don't have to give it any deference. Is that what you're saying?
I believe the PPP speaks for itself in that manner. It says it's subject to this board making a decision.
Okay, thank you very much for your answer.
Okay, now I see Commissioner Asha has a question. Thank you. Proceed.
Yeah.
Our break.
Okay, I was just wondering, if you said that you folks would have to build a small package plant if the big thing doesn't happen in time. But does that mean that you still have to be pay for the big portion of the big plant that's when it does come in play? What happens if it's like you have to pay double, it seems like that.
I hope that doesn't happen, but if it does, we wouldn't have to contribute, and we'd have to seriously reevaluate the conditions of the PPP because they are based on the concept that the county would build its central regional treatment plant. Thank you.
Okay, any additional questions from our commissioners? You get to 100% pretty soon here. Okay, okay. Oh, as in light of the fact that it is currently 12 minutes after 10, we will take a 10-minute break and come back at 10:22. Okay, thank you very much. Are we good with that, commissioners? Are there any additional questions anyone would like? Okay, go ahead, Commissioner Kamakea Ohelo.
Hello, Madam Chair. I don't necessarily have a question for the petitioner, but more so a comment. In reflection of the proposed expansion of the school, and the consequence of that is more densely built homes. I guess my comment at this point in time, Madam Chair, would be for the petitioner to be sensitive to the cultural impact of building dense communities in this culturally sensitive area. And please be mindful that the potential inadvertent fines of iwi kupuna. Yeah, and I really just wanted to comment upon that and make sure that it's on the record. That even though this land was previously zone ag and the DBA was approved in 2018, we understand from the past several years, the Wailuku area being highly sensitive with iwi kupuna findings. That is all, Madam Chair. Mahalo.
Thank you. Petitioner, would you want to comment on that then?
Understood. Just want a quick statement. So we're adding on additional 12 or 13 acres to a school site. It was a residential area, so we have 222 acres of residential. So it shouldn't be overly dense. That's our hope. It's 12 out of 222 isn't like 12 out of 30 or something. So that's just my point. Thank you.
Okay, thank you. And now Commissioner Okuda would like to speak again.
Yes, as a follow-up question to the petitioners, what, excuse me, what specific actions can you represent to the commission which addresses Commissioner Kamakea Ohelo's concerns that he just stated, since based on the Constitution of the state, all state agencies have a duty to protect and preserve these types of cultural resources. Can you answer that question?
Thank you, Chair. I believe there was a Kapa'akai analysis done for this project during the initial proceedings, and every permit will be reviewed by the Department of Public Works, and per 6042 HRS, if they deem it necessary, it will go to the State Historic Preservation District, the permit for review, and naturally we'll all comply, us and the other developers working there will comply with the findings. Thank you.
Okay, Commissioner Kamakea Ohelo.
Mahalo for the answer. At this point, I appreciate the answer, and I would just like to urge the petitioner to please engage the community. Yeah, and just be prepared, because I've seen the Lahui Kanaka show up and shut down construction sites and job sites to protect iwi kupuna. So part of the mitigation plan, I guess, or the preparation work, I believe you need to engage the community. So mahalo nui, Chair, for the time.
Thank you, Commissioner. I will ask again, are there any more commissioners that would like to ask questions or make statements in regards to the petitioner's presentation? We will now conclude this portion of our hearing. I'd like to move ahead now and ask for the County of Maui to please make their presentation. Mr. Hopper.
Thank you, Madam Chair and members of the commission. I'll try to be brief. The county has filed a position statement in this matter. The county supports the amendments to the traffic condition as well as the wastewater condition. We have no objection to the condition dealing with the school site change. We believe that's a matter for the State Department of Education and the developer. As far as the changes to the county to the traffic and wastewater conditions, we would note that the current conditions require basically the project to mitigate all project related traffic impacts. Sorry about that, and to provide the mitigation for the wastewater for the wastewater generated from the project, both pursuant to agreements with county agencies. So for the case of the traffic improvements, there's to be an agreement, which they call a memorandum of agreement with the County of Maui and the Department of Transportation to determine what traffic improvements are required of the project and how the developer will be mitigating the impacts of the project and what their pro rata share of those projects would be. There's not a specific list, for example, in any condition that goes over here are the traffic improvements required by the project. So the LUC condition was always, and this was discussed at the hearing. I was present at the hearing with the approval that the specific traffic improvements would be done pursuant to an agreement with the County of Maui. That's not going to change as far as what the determination of which improvements are required. However, rather than providing money, essentially, affordable units would be used to satisfy the monetary requirements. And my understanding is that the traffic improvements thus far that are contemplated, that the developer would be contributing a pro rata share to those improvements. So the improvements would be done by the county who would be the owner of the roadways where the traffic's being mitigated, and they would essentially seek reimbursement from the developer in a case where no affordable units are allowed. In this case, if the LUC amends the condition, it would allow, rather than the monetary contribution for reimbursement, it would allow for affordable units to count as that towards that contribution. Again, though, there would still have to be an MOU with the County of Maui outlining what the improvements would be, and the change of the condition would allow the use of affordable units to satisfy those requirements. So that's the only difference in the conditions. The conditions now say they will mitigate the impacts, the traffic impacts of the project by an agreement with the county, where they will pay their pro rata share for those improvements. In this case, this would give the option of the county to accept workforce housing units in lieu of those contributions. I think it's ultimately up to the Land Use Commission if it's comfortable with that arrangement, but the County of Maui does support that arrangement because it provides additional residential workforce housing units, and because the projects have to be built in any case, but it's not that the project is going to be solely responsible for those improvements. It will be paying a pro rata share. The county supports that arrangement because it provides additional workforce housing units and still retains the original intent of the condition, which is to have that agreement with the county to outline those improvements, but allows for workforce units to be used in the contribution rather than essentially money. As far as the wastewater condition, it's essentially the same wording. It would allow additional workforce housing units to be used rather than contributing toward the cost of in this case, a Central Maui wastewater treatment plant. The option still exists for a private wastewater plant to be built. That would be, separate for a separate thing that the developer would do as required by state law, but would allow for the public-private partnership agreement. The terms of that agreement would allow for, again, those workforce housing units to be used in lieu of that financial contribution. The county would also note a couple of things. I think we already mentioned that the idea for the traffic mitigation was that there would be an agreement with the county and the state for state highways. outlining the specific list of improvements, that there wasn't an independent list of improvements that, for example, the Land Use Commission set out in a condition. From time to time, Land Use Commission and other agencies may set out specific traffic improvements that have to be done. In this case, it was, and I believe Public Works Director David Good testified to this at the time. The idea was to come up with sort of a master roadway agreement that would agree upon the timing and the pro rata share for the various improvements that would be required for the traffic mitigation. The only other thing I would want to address is the binding nature of the public-private partnership agreement. There was a question about it being recorded. Well, it's not recorded. There is language that states binding effect. This is on page 7 of the agreement. All the terms and conditions of this agreement shall inure to the benefit of and be binding upon the parties hereto and their respective heirs, personal representatives, successors in interest, and assigns and shall run with the land. This agreement shall be for the benefit of the parties herein. So I think that shows that if if the project is sold and these the conditions are still unfulfilled, that would go on to the next, if there's another developer who's developing the land, they would still have to abide by the same requirements of the agreement. Otherwise, they would, be subject to, they would still have to mitigate their impacts by using monetary contributions rather than, residential workforce housing units if it doesn't comply with the terms of the agreement. So I hope that clarifies that aspect of the agreement, and we're available for questions if you have additional questions.
Thank you, Mr. Hopper. Okay, commissioners, questions, Mr. Huikashi from Maui.
That public-private partnership agreement, would the county want that agreement to be included as part of any part of the DNO?
I don't think so. I think the condition would allow, the conditions were general in the first place, saying that you have to come to an agreement with the county on your mitigation. This allows, as part of that agreement, to consider the number of workforce units, but still leaves it to the county and the developer to come up with that arrangement. So I think the agreement is a matter of record before the commission. I'm not sure what else would be done as far as the condition being amended, but I don't know of a need to do anything further with respect to the language of the condition.
Would it assist in making sure that the agreement stays in place? And I'm talking about the county, because we all have, in politics, we all have limited terms or sometimes impose on us a change of terms. But this agreement, in order for it to be effective, needs to go on for several years, I would imagine. Wouldn't the county want to include it as part of the DNO, as a statement within the DNO to adopt the terms of the public-private partnership agreement?
My only concern is that if anything at all changes, I don't know if the parties would have to come back before the LUC if there's any changes at all to the public-private partnership agreement. I don't think that's something the LUC is being asked to adopt. I think the LUC is being asked to look at the conditions and asked if it's comfortable to use residential workforce housing units in lieu of financial contributions. So that would,
Michael, I'm not talking about that part. I know what we're being asked to do. I'm just asking about this particular agreement. And the reason why I'm asking about it is that I know that the county will hold hostage any future developer, or hold to the terms of this agreement, any future developer, or if there's a change in ownership, any subsequent. My question is more, how do we make the developer hold the county to this terms of agreement? Assuming that, and I use the same example, assuming that there is a change of administration and they say, I don't like this agreement. I don't think we should do it. I'm going to rescind it because there's nothing in here saying that I cannot rescind it. And so I'm just saying that if the county is serious about this agreement, wouldn't it be asking that we place it within the terms and conditions of the DNO? So to require any future county government to come in to the Land Use Commission and say, oh, we want to rescind this now. And explain to us why. That's my question to you.
Yeah, I would say the conditions, again, as they're proposed, and I think we prefer the language in the proposed condition amendment, it gives the county the ability, it's not the requirement, but the ability to accept residential workforce housing units. I would point out the successors and assigns would apply to the county as well. That language is.
I'm not
just to
talking about the
developers.
successors and assigns. I'm talking about you guys. What if the developer says, I want this thing to continue? And
Right.
you guys are no longer there. And they're saying, and the guy's saying, well, we didn't sign this.
Well,
It's totally new to us.
I think a new mayor or the other directors, it does say successors and assigns both ways. So it's not just.
So are you
just-
saying then that this agreement can bind any new administration to the terms of it?
I think that the terms of the agreement still allow and require other agreements to be entered into to determine the actual.
Wait. But
number
that's
of
not my
units.
question. My question is, this agreement binds future administration.
Yeah,
Is that your position?
I believe so, because it
Okay.
says successors and assigns in it. Now, the agreement itself allows for, still requires other agreements such as a traffic mitigation agreement and wastewater agreement.
I understand
in the
that part.
future.
I'm just talking about this particular agreement. I understand the part that you need to execute on the terms of any agreement. You have to have additional things that must be done under any agreement, in any agreement that you enter, in any contract you enter. It's called performance, right? So I'm just questioning. My question is that, does this agreement bind the county of Maui to that?
Yeah, if the administration changes, I don't see that you need a new agreement. I think the same agreement would be in place. I would agree.
I take that answer to say, yes, it binds the county.
Yeah, to the terms of the agreement. And
Right.
again, the terms of
I
the,
just want to take that. I just want to get that answer, is that's the county position. It binds the county. The second question then is that there has to be certain agreements or certain sign-offs that the DOT takes place. Are there any traffic improvements that were contemplated that were required on state highways that are being part of this public-private partnership agreement? I just asked.
the state did not sign this agreement. And while the condition would allow the state to accept residential workforce housing units, again, that doesn't require them. So I don't know of any agreement with the state of Hawaii and, perhaps the Office of Planning.
That's
would
not my
know.
question. My question is, are there any highways that would have requirements on it, the state requirements on it? On the state highways that this agreement would affect. In other words, are there any requirements that you are aware of on the state highways?
Well-
Or is this all county highways? That's what you're talking.
Well, again, the final list of required improvements is going to be entered into with an
Yeah, I
MOU, so
understand
we
that.
don't have the final list.
I understand. I want to know whether or not there's state highways that are involved here.
My understanding is that there may be a couple of intersections that connect with Honopi'ilani Highway, which is a state highway for the Waiale Road bypass that may be involved in the improvements required under the county agreement. In other words, they sort of intersect. But
Okay.
again, the state highways may have mitigative measures. Those are not dealt with. They would not be dealt with in an agreement signed by the county MOU.
And I understand all of that. I'm just trying to get to my question. My question is, first of all, yes, there are intersections. Secondly, if the state requires certain work on those intersections, does this agreement contemplate the county of Maui funding those those improvements in lieu of the developer doing so?
If, again, if they are part of the MOU, and I don't have a specific list of all the MOU improvements, I would say at this point, I don't know. And again, that intersection, there's intersection issues. We have the Director of Public Works on call. If we need some more specific information.
No, I'm
on
asking
that,
about this
but-
agreement. And I'm just asking legally. The way I read it is that, yeah, the developer has a chance to negotiate and give these homes that are desperately needed by the people. And I'm all for that, you know, but what I'm trying to get at is that who's gonna actually make the payments? Let's say the DOT has an intersection that is affected and they make certain $1 million worth of requirement. And 50% of that was supposed to be the developer. I'm just throwing out numbers. Does this agreement allow the county to pay for that by the developer giving up workforce housing?
I think that's the idea, is that rather than do their pro rata share, the public basically would have to cover the pro rata share.
All right,
that point.
now, so the public will pay, the county government will pay for these improvements in lieu of getting some additional workforce housing. And I know it won't be a dollar for dollar method. The way it sounds, it would be they're contributing far more in dollars than the actual improvements are anticipated. My next question is that, assuming that the county doesn't pay, does the agreement provide that we get rid of these additional workforce housing? And because my understanding is you need some kind of appropriation from the county council to fund. And I'm just trying to get into the nitty-gritty so I understand this agreement. And so the world understands this agreement. Is that what this thing does? It depends upon whether or not the county can come up with the money in order to pay for the workforce development.
Well, if the units are provided, basically, if there's a workforce housing agreement and they're encumbered, I think that would be the developer's obligation at that point. The county, as it would without the agreement, would be, my understanding is going to be in doing the improvements anyway. They just won't get reimbursement from the developer to do the improvements. That's my understanding, is that currently the developer has a pro rata share in the improvements, but I'm not aware of improvements that they're 100% required to fund at this point, where they would be the ones actually doing the work. Again, that's my understanding from my discussions with the Public Works Director. But until an actual MOU is done, we don't know finally what all the improvements are going to be in their full schedule.
And you just gotta forgive me because I'm not a county lawyer or person or public works director, but what I'm trying to get at is, according to this agreement, they were supposed to pay for money for that state intersection. The state says, we're not playing ball. We're just gonna require you to make improvements. This agreement, assuming that you have an agreement with the county, permits the county to make payment. However, in order for you to make payment, you would have to actually get the money to pay for it. Is that my understanding?
I mean, the county council would have to fund improvements.
Yeah, that's right, right?
Right. I mean, that's
Okay.
that's true of the improvements in general.
Yeah.
Even without the agreement, of course. Because if they're pro rata share improvements, the county, if they're on county highways, the county would be doing the
I'm
improvement.
not talking about
and
county.
getting reimbursed.
I'm talking about the intersections that you were talking about that were part of the state highway division. And I'm just trying to get a clear understanding of how this agreement will work and what obligations that the county has to put it in. And if my understanding is correct, the agreement is that if they're required to pay something by the state, you guys, under an agreement that they provide this additional housing, you guys will cover that amount. And when you cover that amount, you got to go to the council to get it. right?
Well, if you're talking about paying money to the state, the only cases where there's state improvements involved, as I know of, this is page 4 of the agreement, and it talks about intersections of Ho'opi'ilani Highway, sorry, and the Waiale Road extension. In those two cases, I'm aware of those intersections, and that those would be items because the county's already doing the Waiale Road extension, that it would be involved in funding that could potentially involve a connection with the state highway. But generally, the county would not be under circumstances funding the development's state highway improvements. If they enter into
That's
it,
exactly right. They wouldn't normally, right? But this agreement takes their obligation and gives it to you, right?
not in the cases of state required improvements. There's two intersections, items 3 and 4 on page 4, that again deal with the Waiale Road extension connecting to the highway. And because the Waiale Road extension is going to be a county improvement, those were part of the agreement. I don't know of any other cases where the county would ever be funding state improvements.
So
in that case,
they're on their own for the state improvements.
right?
Is that right?
And if
Okay.
they have
All
to have a
So
separate.
if you said that from the beginning, then I would understand. But you said no, you know.
But,
So
well, because
I'm just trying to figure this out. The next question that I have,
okay,
the next question is that I have is the state of Hawaii is not a part of this agreement, but you recognize the fact that the DOT may enter into agreement
that's what
concerning your workforce house development.
if the conditions amended as requested, then that would be, they would be included as an agency that could do that. But again, we would leave it to the DOT
Yeah.
if they decide that.
Why was that put in?
I did not draft the amendment wording, so you could ask the developer that. And as far as the DOT, I don't know if they have any interest in asking for workforce housing units in lieu of state improvements. I can't speak for them on that. And then
Who's a deputy corporate counsel that approved this?
that was
The
myself.
form and legality.
That was myself.
That was yourself.
Yes.
So but you don't know why it was done that way.
If you're asking about the amendment to the condition,
No, I'm asking you this, why was it done that way to allow them to negotiate with the state for additional, in exchange for additional housing?
Oh, that wording is in the condition, in the proposed amendment to the condition. That's not something that we worked on as far as the condition amendment. The condition, we wanted to make sure that prior to this agreement being finally effective, that the Land Use Commission and the County Council were both aware that rather than funding for improvements, they were going to get affordable units instead, because that arrangement was not originally discussed at the district boundary amendment level. So we did discuss, you've got to go to the Land Use Commission and the council to get their approvals before this agreement becomes effective. As far as state improvements, that's again between the developer and the state, and the county cannot bind, and nor does it intend to bind the state in accepting units in lieu of them taking their in lieu of them requiring funding for the improvements.
Well, it was just confusing to me when I read that that the state would be able to waive its requirements in the condition.
Yeah, again, I don't think the MOU or the PPP has anything that would be binding on the state there. And again, you can ask the developer if they've had any discussions with the DOT on that point. I don't know, and the county doesn't know. This deals with county improvements.
And just a comment, you do understand that my concern about special use permits being used for large industrial type of developments.
We've been over with the Central Maui landfill. We've definitely discussed that at length.
All right.
I will say that the wording in the condition deals only with a private wastewater system special permit. It doesn't discuss, public. And as far as the Central Maui facility, I'm not sure what their plans are as far as, entitling that facility, but I think we can note your concerns to them, certainly. But the condition, when it talks about a special permit, I think that referred only to the then potentially contemplated private wastewater system, which
So-
would have been done by the developer.
So then it's your understanding that it only applies to that,
The condition, well,
only applies to a private developer, not to the
I-
county of Maui.
yes, I can look at it again, but when I reviewed it, here's what it says. If the private wastewater source storage and transmission facilities are located outside the petition area and within the state and county agricultural districts, petitioner shall apply for a state special permit in accordance with the provisions of HRS 205. So that says if the private wastewater source storage and transmission facility. So that's the language. And I think that is intended to apply only to the private system that the developer would be developing.
Would you be adverse to having it language put into that portion that says that this procedure is limited to a private development?
I honestly, I don't believe that language is necessary. We'd want to review, any of that language, but if it applies only to a private system, I think that's what it already says. So I don't think there'd be a problem with that. You would,
Well,
I mean-
my problem, Mr. Hopper, is like seeing statements about underpasses, overpasses being sort of like reinterpreted by different individuals and entities. And I just want to be sure. It wouldn't affect you guys, would it?
no, I mean, it says that the private system
All right. So,
that shall apply for a special permit. So if you want to be really sure they apply for a special permit for that facility, I guess you could clarify that.
I
But
would limit that portion, it would be limited to private facilities, right?
yeah, I think it says, yeah, I think the
You
intent,
don't have any problem with that, do you?
I suppose not, no.
Okay. No further questions.
Sure. Okay,
Thank you, Commissioner. Commissioner Okuda, you have questions now?
Yeah, thank you, Ms. Chair. To follow up Commissioner Ohigashi's questions about, let's say if the commission were to grant the relief that was being asked, Mr. Hopper, you do agree that whatever representations are made in the course of getting the commission to make a decision, parties are essentially bound to follow their representations. In other words, people, and we're talking not only about the county, but the private petitioners, interveners, or what have you, if certain representations are made in front of the commission and the commission relies on those representations to make a decision, the party is not generally allowed later on to disclaim the representations made. In other words, people aren't allowed to say, okay, I represent this, you get the approval, and then later on say, it's not real clear, so we're not going to follow those representations. You do agree that representations have to be followed, correct?
That's correct. However, I would say, I think it's, in my experience, it's also very important to have clear wording in your conditions and things like that, because we've certainly seen in the past that it can be difficult to rely on a transcript or a record in order to determine the specific obligations. I think generally, yes, you're correct.
Yeah.
But I don't think it's a substitute for well-worded and clear conditions.
Okay, and to keep the final order or whatever order arises out of a hearing so that it's very clear, would the county object to having attached as an exhibit to whatever order comes out of this hearing if the Land Use Commission were to agree to the petitioner's request, which the county has joined? Would the county object to having, for example, the public-private partnership agreement attached as an exhibit so that it's clear that that was the document that the commission was looking at and relying on in making its decision?
I think you could attach it, but I would say the wording of the condition allows for the county to accept units in a, as that, as in lieu of a contribution, and still has to allow for that sort of master roadways agreement to be entered into to outline all the impacts. In other words, I don't want to limit the ability of the county to enter into those agreements that finalize the obligations of the parties. And I don't know if doing that would then require, if there's any changes or amendments to that public-private partnership agreement, do we then have to come back to the Land Use Commission in order to have that DNO amended again? That would be my only concern.
Yeah, and your concern is noted, and I understand your concern, and your concern makes a lot of sense. But just to try to keep the record and the final order clear, which seems to be everyone's intention and goal here, would the county, assuming we have the clear conditions placed in the order, would the county object to including the public-private partnership agreement as an exhibit? It can be part of the whereas clauses or what have you, part of the recital saying that this was the document that was presented to the Land Use Commission as part of the petition or the petition that we're hearing today, just so that, again, as you point out, in the future, people don't have to search the record, the transcript. They can just look at one document, meaning the order that comes out of this hearing, and know exactly what took place.
I think it's in evidence. I think you could reference it in the whereas clauses of the DNO, but I just want the issues I raised to be noted, because again, I don't want to have to, come before you again if there's.
Sure, but taking all that into account, you wouldn't find it appealable error if we were to just attach the agreement to the form of the order, correct?
I suppose not. I mean, it's up to the commission, but again, I just want those concerns.
Yeah, I understand the concerns. Let me move back to my other question that I asked the petitioner, and that deals with deference to the county and the agreement that was reached and the standard of review, if we can call it that. What does the law say, if you know, as far as what deference the Land Use Commission should give to this agreement that was signed off by the mayor and approved, at least, based on the signatures of the different departments and the petitioner? What does the law say about what deference we should give? And if you don't know what the law says, then you can just tell me you're not sure at this point in time.
I don't know of anything in the law that would require you to find binding effect of the agreement in particular, because the agreement says the covenants herein shall not become effective until the conditions of the CIZ and DBA are amended to reflect the terms of the agreement, including the use of residential workforce housing units to satisfy infrastructure requirements.
Yeah, well, let me clarify my question, and this will be my last question, maybe to clarify it. When I talk about deference, as an example, does the law require us to give deference to the agreement, even if, we might feel like, well, gee, if I was negotiating this, I wouldn't have done that, but we should give deference because, we're not on the ground here on Maui. Does the law say we have to give that type of deference, or you don't know one way or the other?
I'm trying to understand the question as best I can. I think that if the LUC condition requires the county to determine the specific, traffic improvements and wastewater contribution share, and authorizes that to be done in the condition, then the condition gives that deference. If the condition says you have to do XYZ traffic improvements, then the county has a lot less deference in that case, because you're outlining exactly what the improvements are.
Yeah, that's not what I'm talking about. I'm talking about just for us to agree to the relief that the petitioner is asking for in the petition. It's basically supported by this agreement. Let me ask it this way, and then this will be my last question. does the law require us to somewhat look the other way, even if we might have doubts about the wisdom of this private partnership agreement? Because this is kind of like an issue of, I don't want to say it's a home rule issue, but it's something that's hashed out at the local county level. So we should defer to the judgments of like your planning director, or is this something that it's like a de novo? We can just take a look brand new and we can take into account what your planning director thinks and then what the county has evaluated, but we can just take a brand new look and say, no, we don't like this.
I think as far as considering the amendments, you do have the ability to decide if you want to allow residential workforce housing units to be used to satisfy those contributions. As far as the specific terms of the agreement, I do think once the condition, if you do decide to, in the condition, allow the use of residential workforce housing units to satisfy infrastructure requirements, and then say it's up to the county to come to an agreement as to how that's done, then you are giving that deference. But I do think you'd have the option to not grant the amendment, and then they would have to go through and provide their pro rata share as they would have to under the original agreement.
Okay, I'm sorry, Madam Chair, I have one, actually, this will be the last question. And maybe Ms. McLean can answer this question in summary form. Why is this agreement in the best interest of the people of the county of Maui? And Mr. Hopper, you can answer on behalf of the county, and then we don't have to swear the witness in.
I mean, again, this was done by mayor and directors who are the policy experts in this matter, but I believe because of the desperate need of affordable housing and because of the nature of the improvements, I think that those departments felt that getting the affordable units was worth it in this case because of, again, the desperate need for those units and the location in an area that was already planned to be urbanized, to take that opportunity to have those reduced, reduced units to be in those areas was seen as a prime opportunity by the mayor and the directors. I think that they felt that was a paramount concern for the county, and that's why they wanted to move forward with that arrangement.
And as this project moves forward, will the county be cognizant and consider and keep in mind the comments of our cultural Commissioner Kamakehe Ohelo?
Yes, I think that's something the county is always required to do, certainly.
Because it's something that the Constitution and the statutes require, correct?
Correct.
Thank you. No further questions.
Thank you, Commissioner Okuda. And now Commissioner Ohigashi would like to have the mic again. Okay.
I'm just curious. I gotta get this straight. What you're telling us is that this is an agreement between the both of you, and that this agreement says that you got to go to the Land Use Commission and get these amendments done. And as part of this petition or this motion, the petitioner says, "Okay, I'm going to show this agreement and put it into evidence as part of to say that, hey, this is our agreement and we want to get these changes done and abilities to do this so that we can go that, so we can do that." And that's why you're saying, well, it's not necessary to be part of the commission's kuleana to put it into as part of the record that requires you to requires to come to us every time you want to make a change in that particular agreement. And I'm not talking about making agreements that are contemplated under that agreement. I'm just saying anything to that specific body. Is that what you're saying?
Not sure I understand the question, Commissioner.
Okay,
sorry. If you could rephrase.
Perhaps it was just me trying to figure it out in my head of what's going on. The next question that I have is that I'm going to scratch that question. You have two things that are required under this agreement. One is to get LUC approval. And what kind of council approval do you need? What is it? A resolution or what?
Well, they did pass a resolution in support of the idea, but they will need to amend their conditions of zoning. They actually have some conditions of zoning that are more specific than the LUC conditions on traffic improvements and things. And so those conditions will have to be amended similarly, that allow for residential workforce housing units to be used to satisfy traffic and wastewater requirements.
And does the county have a timetable of when this will be done?
I'm not aware of a time frame for that. I believe there's discussion of that being a county initiated change. In other words, the planning department, planning director is able to initiate that type of change. But as far as a specific time frame, because that's something that's done by the county council, that's once that's submitted.
What about this question? The question is, when are you guys going to submit a change or not?
I can have Director McLean, because the planning department is an authorized agency to submit a proposed change. If you'd indulge, we could have Director McLean sworn in and she could, I think, assist with that question.
Okay.
Okay, Director McLean, can I go ahead and swear you in? Go ahead and state your name and your position again for the record, please.
I'm Michelle McLean, the planning director for the county of Maui.
Okay, and you swear that all that you're going to say is affirm that it's the truth?
Yes.
Okay, thank you. Go ahead and proceed.
We have draft language for revised conditions of zoning. And once the land use commission acts on the request in front of it today, then we will take that to the Maui Planning Commission first, and then they will make their recommendation to the county council. So we're ready to go with that as soon as the Land Use Commission concludes this proceeding.
Okay.
Okay, Commissioner Hoigashi, are you?
Well, yeah, except that, congratulations, Michelle. Your announcement at,
Okay, thank you. Commissioners, any other comments?
Do you want to take a break or do you?
No, because we didn't reconvene until 10:24, so I'll go to that time frame.
Okay. Thank you. I don't want to beat a dead horse, but yes, but what I do want to ask is, it is, and I guess I'm speaking more in concern with respect to the community. I understand this is a policy decision that those who have agreed to this in the county are balancing various interests and have determined that workforce housing is a priority. But my recollection is that when we heard this matter, wastewater and traffic were by the community, the surrounding community was their priority. And what I have not heard is how the county has gone back to the community to inform them of this change, because in my mind, the benefit of having the developer be responsible for this infrastructure is that they're going to do it in a timely fashion, because they cannot build their houses without this infrastructure. Unlike the county, you need an appropriation, you need public meetings. And so to me, that is valuable from a community standpoint to have this infrastructure timely built. So what kinds of guarantees is a county going to provide that, one, the community is going to be informed of these changes and that the wastewater and traffic may not be timely constructed as they thought. But what assurances does the community have that the county is going to timely build this wastewater treatment facility and complete those traffic improvements?
Well, I mean, the traffic improvements, again, would be seeking reimbursement from the developer, even if this agreement was not in place. So the county would have to do that Waialae bypass. There was also a no Waialae bypass scenario evaluated by the developer at the request of the land. I think that was a land use commission requirement. So the project has the potential to proceed without that particular improvement. But the improvements required by the project would have to be, my understanding is, would have to be done by the county with reimbursement from the developer, even if the current conditions were as they were. In other words, I don't know of any fast track infrastructure that the developer would be building in advance. It's all pro rata share because the improvements are of the nature that they wouldn't be contributing 100%. They'd be reimbursing. So I don't know if the timetable is necessarily changed by this agreement. As far as the Central Maui wastewater treatment plant, that's a major improvement that the county's going to need to build, not just for this project, but for others. This agreement does allow for a temporary connection for several hundred units. But beyond that, other than building the private facility, there's not really a county option for connection other than having that facility built. That's my understanding of the background. Again, we do have county personnel on call that we could ask for specific answers to those. But I think with the infrastructure, there's timing issues whether or not the public-private partnership agreement is in place because of the nature of the improvements. Other than the private wastewater treatment facility, that could potentially be more of a fast track issue, but I don't know if there could be complications with building that. We may need additional entitlements and things. And so the Central Maui facility, I think, would be the long-term solution to that. But again, there's not a lot of other options other than the temporary connection for some of the units, as I understand it, to provide wastewater capacity for the project other than a private system.
So my understanding is that the developer can proceed forward with 300 units as soon as they get their subdivision approval, because they're going to be permitted to connect up to the county wastewater treatment. Anything beyond the 300 would be dependent upon the county constructing the larger wastewater treatment facility. And therefore, at that point in time, the developer would okay, my understanding is that with this exchange of workforce housing, the developer would not be contributing their pro rata share for the wastewater improvement. But if they wanted to escalate the development of the wastewater for their development beyond the 300, then they could do their own private facility. Is that correct?
I think maybe developer could answer some of that, but I think that's generally the understanding that I have of the different wastewater options. But I think the developer could confirm that if I'm mistaken.
Mr. Ueoka, Madam Chair, could Mr. Ueoka confirm that?
I believe they're conferring on that now. Mr. Ueoka, can you comment on that question about the wastewater options?
Sorry, just could you?
Okay, so my understanding is based upon this this proposed modification, the developer will be able to timely proceed on building 300 units once you get the subdivision approval. Because you'll be able to connect up to the county's existing wastewater facility. Anything in addition to the 300 to meet your 1,400 would be dependent upon the county's building the larger facility, correct?
Yes, that's correct. And can I clarify one thing? I believe we have the understanding with the county that if we're done with the 300, we can apply like anyone else to get, if there is additional capacity in Kahului. If we're ahead of the game, we can apply like everyone else. Our goal, of course, is ultimately to get into the central. We want the central built we probably want the central built more than anyone else right now. Thank you.
But the other option is if you wanted to expedite your ability to build that additional 1,100 units, you would then build a private facility. And under this agreement, you would then come back to LUC and the Planning Commission through an SUP for that private facility.
Yes, at the point of the 300, depending on the timing, and we'll work with the county we really want to connect to the central. We want the central and want to connect there. Please understand that's our priority. But at the end of 300, when we're built out, yeah, we will have to look at our game plan moving forward. And we do have the option, and there will be entitlements needed for us to build additional entitlements needed for us to build our private wastewater treatment facility.
Okay, thank you for your response, Mr. Uyoka. So I guess back to the county, and that, and I share the sentiments by fellow commissioners Ohigashi and Okuda. I know I'm not here to question the county as a policymaker. You are evaluating your needs, and you have determined that the workforce housing is a priority. But at the same time, you have an impacted community that surrounds this current area who raised these concerns to us 5-6 years ago, the same issues. And I also hear them raising it again today. So I think it's incumbent upon the county that if you're going to make this determination where the burden will be borne to a large extent by the existing community, that you are re-engaging with them as well and informing them of the modifications. And am I correct to assume that you will be doing that through the Planning Commission meeting?
I was actually just going to note that. I think that's where you were going. If the commission does approve this and there's a proposed change in zoning, initiated by the county, there would be a public hearing held at the Planning Commission, as well as at least 2 readings at the Maui County Council to amend the zoning conditions. So there would be those additional proceedings as well if the commission decides that to approve the amendment. So again, those conditions would still have to be amended, and those proceedings would have to happen before the Planning Commission as well as the County Council. So that's correct.
And in your do you have a notification requirement for the Planning Commission meetings? Is it just a public notification, or do you notify people specifically on a list?
I think all agendas go to people that have, I think there's a list of everyone who gets the agendas, because it's a department initiated, and rather than an applicant initiated, I don't think that there has to be notice to owners within 500 feet of the property. But there would have to be, I think, notice in the newspaper published 30 days in advance of the meeting, as well as on the regular commission's agenda. So anyone monitoring the commission's regular agenda would see that. There was already a council meeting on this where they considered it and approved a resolution about it. And there was testimony from community members at both the committee meeting and the full council meeting on those items. So I do note that. I'm not necessarily, as legal counsel for the department, I'm not necessarily the expert in public outreach issues, although they're certainly important. But that's my understanding of what's happened in the background for this. But I think that we can certainly note and can bring back to those that are involved in this agreement that, to get the word out that this is something that, community members want to be informed of.
And I guess this is more of a comment to Mr. Uyoka and Mr. Atherton, who did an extraordinary job in coming to us the first time. I would urge you to go back, whether it's WAIKAPU Community Association, but to those, especially those who took the time out to be here today, to also keep them informed of when that meeting is. And my only final comment, mahalo to our cultural commissioner. Beyond SHPD regarding Iwi Kupuna, I would urge you, there are families who have a connection to that. Those are the ones that you really should be contacting. And I think when you did your previous assessment, you had Hokuao who was extremely, I thought, I think he is a person of that area. And I would urge you to make sure you touch bases again with Hokuau. And he reconnects with those families who are from that area. Right, so mahalo.
Thank you, Commissioner Chang, and thank you, Mr. Hopper and Ms. McLean for your input. Commissioners, any more questions of our County of Maui presentation?
Chair.
Okay. Commissioner Kamakea, oh, hello.
Mahalo, Madam Chair, for the time. Mahalo, Mr. Hopper. And I think I more so have a comment than a question, but if you have an answer for my comment, then I would love to hear it. You know, between Kahukuloa and Ma'alaya, there's approximately 8,000 homes. Yeah, and with the addition of this 1,400, I believe it'll apply more pressure on the singular one firehouse in Wailuku. So I guess my comment is more so public safety and the community impacts. So I believe that it's the kuleana of the planning department to look far enough ahead, yeah, in the interest of public safety, to also include within your guys' agreements or plans, yeah, to maybe build out an additional firehouse, understanding the history that Maui has with fires. So I guess that's my only comment at this point in time. Mahalo, County. Mahalo, Madam Chair.
Okay, thank you for your input, Commissioner. At this time, we would probably be looking to do a break, but let me check in with our staff. Would you like us to take a break now and break for lunch later? Or is lunch here, it appears? So would you like to go ahead and we can do a lunch break now? Ariana, I'm sorry. Okay. Oh, well, I mean, you've got to make sure the lunch is here and the beverages, whatever we want to do. Oh, wow, such power. Let me think. Huh? I know I see them. They're here. I just saw them. Okay. Okay. It's been suggested that perhaps we could listen to Mr. Yee's from the Office of Planning and Sustainability with his wonderful and usually perfectly concise and brief presentation. Would you like to proceed? And then we'll see how many questions we have afterwards. Thank you.
All right, I will proceed with the knowledge that I'm the only thing standing between you and the food. The Office of Planning and Sustainable Development supports this motion with some trepidation because I may only be inviting questions. I have a few comments. The first is we support this motion because we support affordable housing. And there's just no getting away from that issue on why it's important that we proceed. We understand that to a certain extent, there is now a transfer of responsibility from the petitioner to the county. And we have to trust the county in a certain extent. We've gotten certain statements that give us some faith that they will do it, but ultimately we will have to rely upon the county to put in the traffic improvements or the wastewater treatment facility that were going to be contributed to by the petitioner. We also think it's a good admonition to remind both the petitioner and the county on the importance of community outreach. But having said all that, we do think the county can be trusted to do this. And we think it's appropriate to do this because of the importance of affordable housing. Let's make this option available to the petitioner and to the county to move forward with this possibility of having more affordable housing on Maui and allowing them the opportunity to change up a little bit the way in which we fund some of these projects in order to get affordable housing. If the county can get federal money instead of using petitioner money, and as a result we get more affordable housing, that's great. And yes, the details are going to have to be worked out. And yes, there's going to need to be community output moving forward. But we think the opportunities are there. We think actually structurally it's required for county approvals. And we think that the petitioners had a fairly good track record of community outreach. And so we think we are assured, we have a certain amount of comfort that this can be done and be done correctly in this case. With respect to cultural resources, this is always an important issue. We're happy it was brought up again. We just want to note that there is nothing about this motion that should negatively impact cultural resources. Nothing about this motion affects their obligations under the law and the Constitution. And in fact, I think the transfer of or the construction of a school rather than houses on that property really does not have any significant change to the impact of cultural resources. Both will be developments. To the extent that either of them impacts disturbance of the land, the iwi kupuna protections are set out in law and will have to be performed regardless of the particular use of the land. We want to acknowledge that we have heard the comments regarding the Department of Education and its commitments to fulfill its representations, as well as the comments regarding special permits. So I have nothing more to say other than to say that I've heard and understand. To answer the particular question, just because he will probably ask me, the PPP is not binding upon the Land Use Commission. The deference that is provided is not given because it's required by law. It is given because the LUC thinks it's a good thing to do. That the Land Use Commission will look at the fact that it has a role in the land use process. It gave its approval. The subsequent approvals go to the county, and at a certain point in the development of property, if the Land Use Commission so desires, it may say, you know, I'm going to leave some of these decisions to the county to make decisions as to what is the level, how many affordable houses should be provided, how much less money should be paid for mitigation. And we're going to allow the county to make that call and to rely upon them to make a good and sound decision based upon the PVP that you have before you. I think it gives you some comfort that they will make a good decision based upon some of the information you got today as well. But that ultimately, as is true in most Land Use Commission cases, approvals, it just flows from the Land Use Commission to the county to make further decisions at zoning and subdivision. And once the reclassification decision has been made. So that the deference is not required by law. It is really given because the Land Use Commission, I think it is a good idea that the Land Use Commission allow the county that flexibility, that you not have to say, I would not have made the same decision. It is simply, I think the county is applying the proper analysis, and we will allow the county to make that decision. And then finally, just in case you do ask, I think it's fine to include the PVP as an exhibit. It's probably better to include it as an attachment or as a reference to the findings of fact rather than to a condition. But other than that, we would have no objection. And those are all the comments that I have. Thank you.
Thank you, Mr. Yee. Okay, commissioners, do we have any questions at this time? And we can see how many of those we have if we want to try and conclude or go to a break. Commissioner Higashi. Excuse me, at this time, I keep forgetting. Sometime in the last, when Mr. Hopper was making his presentation and our answering questions, we had Attorney General Morris leave the room, but Attorney General Gina came in, and now since then, Mr. Morris has returned. I'm just trying to keep track of who's in the room. So anyway, so I don't know what time all of that took place, but I hope the technology keeps track of that. Okay, thank you, Mr. Ohigashi, go ahead.
Yeah, as a general thing, isn't, just following up on you, isn't it correct that the county has the enforcement powers under the original DNO?
The county certainly has the enforcement powers. Certainly one substantial commencement has occurred on a project. The Land Use Commission's, jurisdiction is very limited.
Okay, and would those be, would they have indicated that the applicant's fair share will be negotiated and not require them to come to the Land Use Commission with these modifications? In other words, they can say that, yeah, they're going to pay for their fair share this way rather than the other way. Because as I read the DNO, it doesn't indicate anything.
My recollection is that DNO anticipated that there was a TIAR, and pursuant to the findings of the TIAR, which is a technical document, contributions would be made. In this particular case, the TIR is going to indicate a certain level of contribution should be given, but for the regional fair share, but will not have to be given pursuant to this alternative.
Right. And isn't that an administrative, or wouldn't that be part of the county's determination as to whether or not they would accept that as?
It would be factually untrue because the TIR is going to indicate a certain level of contribution.
Right.
So it's not going to be consistent with the TIR if the county simply says, I deem your fair share to have been satisfied, because it would not, because then the county would not be complying with the TIR as required by the existing condition.
And so this had to come to the Land Use Commission. Is that your position?
Yes.
Okay. All right. If we modify it and we accept the amendments, does that render the TAIR analysis kind of moot?
No.
And why is that?
Okay, so, and if I go too far into the weeds, stop me.
Stop.
Okay. Generally speaking, there are direct impacts and indirect impacts that are listed in the TIR. And I'm sorry, I didn't look at this one. But the direct impacts are generally the ones that are required solely because of the project. So it's the intersection into the project would be a direct, you need to put in a stoplight just because the traffic is going to be so big. You need a holding lane, et cetera, just for this project. In addition, there are the indirect impacts. It'd be the impact to the H1, it'd be the impact to Honopi-Ilani Highway. It is, you're not going to be responsible for the entire improvement because you're just part of the reason why improvements are made, but you are contributing. And so you're going to need to provide a certain, basically monetary contribution. And what they do is they add all of those impacts up for everything, and they come out with a dollar amount. And then most generally what they do is they say, okay, so if your dollar amount is $25 million for everything, this is my next project, pay me for this project. And you pay for that and you satisfy everything.
But
that's what's good. That the TIR analysis for that becomes moot because they're not going to have to pay it. But the TIR analysis for the direct impacts are still relevant. And so it doesn't become moot and because it'll still have to be done.
so the answer is yes and no.
Yes, correct.
Okay. And the TAIR analysis that you mentioned that would render moot would be those impacts that the county has jurisdiction over. Because as I understand the agreement, explain to me that the counties, it only applies to the county, but the state improvements are going to be required to be.
Well, it's subject to state DOT approval. So nothing in this, it simply allows the state DOT to say you don't have to pay, but the state DOT doesn't have to say yes.
Okay.
So in that case, I suppose it's also relevant for that analysis. And, I will also say to the extent you're talking about direct impacts to county lands, the county could say you don't have to pay for any of this. Right. So I mean, I talked about direct impacts and generally it is allowed by this condition for the county to say, no, that's okay. You don't have to pay for any of it. I'll pay for all of it.
And who's going to get to say all that stuff?
Well, that's the agreement between the petitioner and the county.
Who's going to determine, say, hey, you don't have to pay for that?
The county. Well, the county and the petitioner would never say no, right? But it technically would require their approval. So essentially, it's the county. Because otherwise, it's the county would have to pay for it, right? So if it's an improvement to a county road, the county would have to pay for any improvement.
Okay, no further questions.
Thank you, Commissioner Ohigashi. Commissioners, any more questions of Mr. Yee? Okay. I'll come back to the commission now. It is now 11:39, and would you like to take a break now for approximately 45 minutes for lunch, or see if you'd like to go to first petitioners having a right to do a rebuttal, and I don't know how much time that would take, as well as then we could have a public testimony. Do we know if there's any additional public testimony that would like to be heard at this time? Okay, just for our timing. And then we would be able to deliberate. So what is the pleasure of our commission at this time? What's to keep going? Okay, everyone in favor of keep going? And then we can eat lunch on the lawn. Okay. Okay, so at this point in time, if everyone else has the stamina to keep going, that means without a break even for 15 minutes or 10 minutes at this time. So if you're okay with that, we'll go ahead and keep going. And if there's no more questions of Mr. Yee and the Office of Planning and Sustainable Development with the state, then I'll go to the petitioner with your ability to make a rebuttal at this time. Okay.
Thank you, Chair and members. I'll try to keep it brief. Just for clarification of the record, I don't believe we're not going to pay anything. We're contributing residential workforce housing in lieu of direct contribution, cash, or funding. So we're not paying anything. It's in lieu contribution. I just wanted that clear for the record. The other clarification I wanted to give was, we do understand the concerns the community had with wastewater. Even if we were to move forward, our treatment plant was a private treatment plant only for WAIKAPU Country Town. The permitting, our EIS and everything only permitted us to take the flows from our project, because the initial conversation with the county was, hey, why don't you guys build a giant one and we'll help you. But when we looked into it further, all of our approvals were only for a WAIKAPU Country Town project. So whether or not we build ours, it doesn't really help the broader community per se, but we will be moving into that bigger facility, which we hope to take recycled water from and everything the same way we're going to take from our facility. In regards to traffic mitigation, I think Mr. Yee gave a brilliant explanation of how it works. So thank you. But one clarification, and I think Mr. Hopper said it too, WAIKAPU Country Town was the main traffic thing that was going to happen on a WAIKAPU Country Town was the contribution to the Waiale Road extension. We were never going to build it. The condition of zoning was that we just pay our pro rata share. So this just says, instead of giving cash for our pro rata share, we're instead giving residential workforce housing. So the traffic impact should be similar in that sense, that we were never required to build it. So I don't think we ever were going to build it either, because the right of way is in favor of the county. So the timing of it shouldn't be affected by the motion in front of the petition in front of you today. So just wanted to clarify that for the commission. Thank you.
Thank you. Okay, commissioners, any more questions at this time? Okay. Any other comments from anyone? And then no public testimony. I think our public has given up on us. So, okay. Okay, if there's no more public testimony and no more questions of the petitioner or any other parties at this point in time, then I would look to the commission to go ahead, and if they're prepared to go into deliberations. and discuss the matter and come up to a motion regarding how the commission should proceed in regards to this matter. Commissioners, what is your pleasure? Oh, okay,
Chair,
yes, Commissioner Ohigashi.
I had it on. Madam Chair, I'm gonna move to accept the amendments that were provided to us by the petitioner to amend the DNO accordingly. However, I do believe, and I don't have it right in front of me, that I would like my motion to include a specific statement regarding this, that the special use permit contemplated under condition number 4 shall be limited to the development of a private waste source storage and transmission facilities by the petitioner. In addition, I believe that the attachment PPPA to the decision order, that the PPPA should be attached as Exhibit 1 to the decision and order.
Attached as an amendment?
No, this is attached.
Just attached, okay. Oh. Okay, he's still writing.
I know.
Oh, you're ready? Okay. Can we go ahead? We do not have a second yet. Is someone ready to second that for discussion purposes, or would you like to hear the motion read? Commissioner Okuda.
Ms. Chair, I would like to second the motion with a slight modification, which I think would be considered friendly, but maybe not. I would like the motion to also, or the motion to also make clear that the reference to a special permit with respect to the wastewater treatment plant in no way is the Land Use Commission adjudicating or making a decision on whether in fact special permits are appropriate to be issued to place facilities such as a wastewater treatment plant on agricultural land.
I accept it.
Okay, there's been a motion made and then a friendly amendment that's been accepted by the motioner. And so Mr. Ohigashi, Commissioner Ohigashi made the motion, seconded it with the amendment by
Yes.
Commissioner Okuda. Okay, so discussion, or would you like to hear this motion again as our illustrious executive director is practicing his shorthand? Okay. Yeah, well, you want to read it for us again? I just think we maybe pulling it together. Mike. Training.
Trainable.
Maybe.
To accept the amendment to the DNO as supplied to the commission by petitioner with a specific statement with regard to condition number 4, that NSP be limited to the private wastewater facility and the PPP should be attached to the DNO as an exhibit. The friendly amendment is that that reference to a special permit with regard to the wastewater treatment plant is not an adjudication by the commission as to whether or not a wastewater treatment plant is an appropriate use under a special permit.
In agricultural land.
And on agricultural land.
Okay. Okay, commissioners, have you heard that, the motion and the friendly amendment, and are you ready to discuss this matter? Oh, okay.
Oh, you calling on me,
I
Madam
don't
Chair?
know, I'm just looking.
Okay.
You've been right on this.
I made this motion because I believe that additional workforce housing is necessary. And it is needed. I'm heartened by the fact that the Department of Planning is ready to proceed as soon as this DNO is issued, or as soon as maybe that we've agreed to it, to seek the approval and amendments necessary for the purposes of getting this agreement in place. I don't know if the agreement will pan out in the future, but I'm hopeful it does. And my comments today have been directed at trying to make sure that all parties will live up to their terms and understand that they're going to have to live up to their terms to make this agreement work. If we're going to have to provide additional workforce housing for our people, for our community, somebody has to pay for the infrastructure. Somebody has to make sure that the roads are not as congested. Somebody has to make sure the schools are provided for. In the past, it's been a lot of requirements on the developer. Make no mistake that this is a lot of requirements on developer also, but it is also incumbent upon the County of Maui to make sure that they live up to their terms and provide the infrastructure. Make sure the roadways, the wastewater treatment is provided for, so that we can build this property out and provide the necessary homes. I wish you guys luck, but I'm going to support this motion.
Okay, let me have the seconder of the motion. Oops, sorry, seconder of the motion. Go ahead and make your comments.
Yeah, thank you, Ms. Chair. I'm not saying that Mr. Yee has put words in my mouth, so that's not it. But I'm supporting this motion, and so that I don't repeat everything he says, I adopt what explanation he recited, because I think he did give the correct analysis. I believe in making our decision, we can rely on the entire record of this case, including the prior hearings. I see no evidence which changes the findings of the prior hearings, except for the points raised in this amendment, but specifically the fact that Mr. Atherton and his team have done things to engage the community, to try to prepare a development which is sensitive to the needs of the community, and try to balance these things out. I believe that the statements by Commissioner Kamake Ohelo are, even though we might say from a technical standpoint, it doesn't need to be said, it really should be said, because many times as we go through this process, we forget about the duties under the Constitution and statutes to protect certain resources and important resources in the community. I also find that there's no evidence that changes my earlier belief, which comes forward to current, that the Maui County Planning Department is very responsible in protecting the public interest. And I don't mean to make my next comments say that it's personal, because I believe it's a, it seems to be the culture of the county planning office. I'm sorry that Ms. McLean has decided to leave government service, because she truly is a good public servant. But I take some comfort that we see no indication that Mr. Hopper plans to go anywhere unless they plan to set up their own private planning consulting firm, and then I'd have some problems about them jumping through the revolving door. But I believe the evidence in the record going back to the original hearing has shown that the County of Maui has not disappointed anyone in trying to recommend and do the things which involve really important balancing of choices that we have to make. I hope, Mr. Atherton, you don't feel like we're just a bunch of bureaucrats, just trying to put up roadblocks. We're entrusted by the state constitution to have certain protections, and we go through this process without the intention of creating roadblocks, but just to make sure that the things that we are charged with in following the rule of law, we actually do that. But in any event, I see nothing in the record which changes my original belief when this docket first came up that Mr. Atherton, his team, do have a commitment to the community. And so for that reason, I ask that everybody support the motion with the amendments. Thank you.
Okay, thank you, Commissioner Okuda. Commissioner Atta?
Yeah, I just want to say that, I support the motion too, and I'd like to thank Mr. Yee for saying that the county was capable and following through on all these things, because in the past the state had sort of a more jaundiced effect about whether the state could or could not do something. And I think that today's exchange says that, yes, you can. And I agree, actually. So I'd say thanks for that. And I'll vote in support.
Thank you, Commissioner Atta. Other commissioners comment? Commissioner Chang.
Okay, no, I too am inclined to vote in favor of the motion. I appreciate creative mitigation. We obviously don't have the resources to do everything, and right now there's the counties and the state have access to financial resources that we don't otherwise have. And yeah, and I recall, Mr. Atherton, your presentation, and that you did take a pause at your development project to re-engage the community. For me, it's also about informed decision-making. And I would, I don't question you. I think you have good intentions. You have demonstrated that. And your counsel has been extremely candid with us. But I think informed decision-making is when there are major modifications like this, it may not be required by law, but it is the right thing to do. And it is consistent with how you have conducted yourself in this community. But to go back to them and to inform them of the changes and why, because I think that they're more apt to be very supportive of what you're doing. So communities are suspicious when they don't know or they're the last to hear about it, right? So you've got a good track record. So I too am supportive of this, of what you are proposing to do. I think we need more creative mitigation to address our ever increasing needs. So thank you very much for all of your cooperation in getting us to this point. Thank you, Madam Chair.
Thank you, Commissioner Chang. Other commissioners for comments at this time? Okay, Commissioner Tamakea, hello, please.
Mahalo, Madam Chair. I too will be in support of the motion. As a farmer by trade, I often scrutinize every time agricultural lands are turned over to be urbanized. However, I am a firm believer in workforce housing. And to understand and hear that part of your first phase, you will be building out a 1-to-1 ratio, including workforce housing. I am in total support of that. As a farmer, we need hands and we need labor. And I find that the petitioner shows good cause. Yeah, so I mahalo you folks today, and that is all, Madam Chair.
Thank you, Commissioner Hamakeo. Hello. Other commissioners want to make comment at this time? Okay, I will, as I get, sometimes now as chair, you get to get the last word. I too am in support of this. And I was here in the hearing in 2017 because we had, I think, our hearings in 17 and our motion in early 2018. And I remember this hearing because it was the only hearing I've been to in my entire 7 years on this commission where everybody that came and testified was positive and in supportive. And I felt like, oh my God, the butcher, the baker, and the candlestick maker all came in favor. It wasn't just like it was, you know, everybody from the office showed up because they were forced to. It was all these different people from different professions. And I remember that hearing. I remember the Olawale hearing a few years earlier, which was a completely different feeling. And we've had another hearing more with the state government that was a different feeling. So Maui's had my most extreme experiences here. And I think that, as Commissioner Chang said, Mr. Atherson, looks like I've known him to be involved with this for 15 years. I've only had 7 years of it, but there's clearly an intention to do a good job. And now that the county has come and said, will you make these modifications and do this, and he's willing to, and having to go through more time delays and more cost. His attorney, I'm sure, assuming he pays his attorney for these little presentations. So, you know, it's just adding to the bill, and developers get stuck with this. My simple math, if you're taking out and you're adding 213 workforce houses and getting rid of 213 marketplace houses, and you take that, so he's trading off potentially about 50 million between wastewater and traffic, which were the guesstimations presented. So if you look at that, he's losing out in a sense. I'm a capitalist. About $235,000 in housing income he could made in that exchange for workforce versus, and that 235,000 per house totals about 35 million. So he's losing out on a lot of money by making this exchange, and yet hoping to save a little bit of money on the infrastructure and that. And the whole thing is then dependent on the county of Maui to do their thing. And I think that you don't know me, but in Hilo, I am sort of the queen of housing, because I've been doing housing real estate management of many, many, many properties for over 40 years. And I am repeatedly realized that our problem is not because the land use doesn't approve the housing, it's because infrastructure is so massively expensive. And government has instead decided that they're a social welfare agency to pay for everybody's problems, and we don't put in infrastructure to take care of the housing, and therefore we have a housing shortage. I am the queen of housing. I know it all. Seriously, I live this every day. I manage thousands of properties. So I applaud the efforts of the developer and Mr. Atherton. And of course, I think he should give all developers a good name instead of somehow the bad name they've earned. And it's going to be shame on the County of Maui if you guys cannot come forward and make this happen between funding and county councils and planning and zoning, because if there's been enough years and had all of this been built, however many number of houses built 15 years ago, we would not have as much of a shortage of housing, because even if it had been built then, it might be a little bit semi-affordable because it would be old housing by now instead of brand new housing not worth $5 million per house, but maybe only $750,000 a house. So I think we need to expedite pushing this forward. Us in private business, time is money, and I would support this in the hopes that you guys get it together and get it done. That's my attitude. Thank you. Okay. Oh, I still have the mic. Okay. Okay. Any other commissioners want to make a comment? Okay. Then I'd like to ask our executive director, Mr. Orndecker, to go ahead and take the vote.
Thank you, Madam Chair, or is it mayoral candidate chair? Okay, the motion is as stated previously. Commissioner Ohigashi, Aye. Commissioner Okuda,
Yes.
Commissioner Yamane,
Aye.
Commissioner Giovanni is excused. Commissioner Atta,
Aye.
Commissioner Chang,
Aye.
Commissioner Kahele,
Aye.
Commissioner Kamakeo O'Hara.
Aye.
Madam Chair.
Aye.
Thank you, Madam Chair. The motion carries with 8 affirmative votes.
All right. I think at this point, I thank everybody for coming and for participating and for putting up with some of our tough questions. And we want to hold you personally liable for all those answers now. Thank you very much. Okay, thank you. Aloha.